Welcome to So You Think You Can Dance. We wanted to build on the model of the codes that came before us to declare as a group that fair use really does have a place in an OpenCourseWare environment, in projects that rely primarily on a Creative Commons license, but can't always take advantage of that for absolutely every piece of content that we publish. But we knew we needed a formal tool to help us ensure the richness of what we were publishing and to make it more useful for our users, but also to lower ambiguity and risk while raising awareness around the issues of fair use. So this is our progress to date. This is where we are. And more or less, we've stayed on track. We've had a really aggressive timetable to get this done. And this is where we are today. In August, the code is written. It's done. It needs to go through a process of legal review by an independent group of copyright lawyers. So you can see that the brainstorming and the planning of the project took place in the latter half of 2008. And the heavy lifting, the research and the interviewing and the drafting has been occurring this year up to this point. So the legal review takes place later this month, and our goal is to get the code released to the public in late September. So I wanted to start the content highlight section by breaking down what this code is and what it is not. It is a tool for the interpretation and application of fair use in the United States in the context of an OpenCourseWare environment. And it's based on the people who actually generate this stuff. It's based on those who create the publications, the faculty that are generous enough to share their educational materials, the general counsels at our respective institutions with whom we work very closely to craft our copyright policies, and the staffers, the people who actually work at the OCWs that do the content capture, do the IP scrubbing, do the formatting, you know, make it ready for prime time. Just as importantly, I do need to talk about what it is not. It's not intended to be comprehensive in scope or international in reach, and Lila will address that question in her section. And it's not to be confused with the TEACH Act, which is already out there, which is for distance education in a closed environment. Our methodology, I alluded to before, the research portion of it took about 3 months. From February to April, we were interviewing each other. We were interviewing staffers and faculty about the work that goes into producing OpenCourseWare. And the findings of this research and the interview process was distilled into an internal report with the really funny title, Swiss Cheese and Skeletons. That was a direct quote from one of the informants about what is left when all the third-party content that we can't keep gets stripped out. Occasionally you get some really thin content on some OpenCourseWares. I can speak for MIT in particular because we suffer from that a lot. This report was, it became the foundation of the code. So that was really what informed how the code was written and crafted. I read that page. Okay, so now I'm going to talk a little bit about the wonky stuff. Over time, fair use has been distilled down into these, sort of thinking about it, into these two simplified standards, transformative use and the amount used in context of the larger work. And based on this simplified standard, OpenCourseWares are really good environments in which to make a fair use claim. So some of you might be asking, well, why aren't you using the 4 factors of the fair use statute in copyright law? Well, since they were introduced in the 1976 version of the Copyright Act, these 2 questions have emerged from the case law as guiding principles for fair use reasoning. And the way OpenCourseWares use third-party content within their publications can fare very well under these simplified guidelines. And quite frankly, it's too easy. The temptation is too great to succumb to what we've been told is a condition called 4-factor-itis. If you hold any piece of content against each of those 4 factors and it doesn't pass one of them, then people tend to think it doesn't count. And we wanted to not be beholden to that convention. As for policy implications, we found common areas around which we had questions, issues of platform, moving material from one space to another. There were questions around, piracy and improper use, and we also talked a lot about the equitable rule of reason. What is a reasonable person going to understand is fair use in this context? So the format of the code breaks into these sections that you see here. We spent a lot of time in the code talking about confusions and realities around perceptions of fair use. So there are a lot of confusions around copyright versus trademark in the OCW environment. There was a lot of overly conservative analysis of copyright's reach in our publications. There was overstatement of copyright's implications for OCW. For example, concern for downstream users and secondary liability. That was a real question that a lot of us had, that we had to spend time figuring out. Many of us, and by many of us I really mean me, have been trained to treat all third-party material alike in course materials, and that doesn't necessarily have to be so. And we also misjudged the scope of fair use. So, for example, we would apply it differently based on different types of content. Is it fair in video, but not in a printed lecture? These were sort of the confusions we had. Situations kept coming up that were common recurrent themes amongst the different institutions. So we would always try to figure out what are we going to do for incidental appearance of copyrighted content in the materials. For example, video lectures being the best example we can think of. Third-party stuff that shows up in critique and analysis, which is quite frankly one of the core examples of fair use in the classroom environment. We encountered third-party material used for illustration, demonstration or explanation in course material, but also what do we do about stuff that shows up in assigned and supplementary readings. The code moves on to the area of principles, where we look at how fair use can apply in each of these situations and why, but also an area of limitations, how considerations to keep in mind in applying these principles to the given situation. So moving it into the home stretch here, this plan for implementation sort of has an external and an internal component to it. The work that's left to be done looks like this. Every code, as I said before, has gone through a very rigorous scrutiny from an independent group of legal scholars in copyright law. And that really is to make sure that it's bomb-proof, quote unquote, so that it really holds up to scrutiny. We are working right now on the issue of endorsements and approvals from our institutions and also outside organizations. And as I said, we hope to have this ready to release in late September. So the internal component of the code implementation is where we need to talk with our general counsels at our respective institutions about how we plan to put this into practice, because we need to be very sensitive to our home institutions' copyright policies and their philosophies about how course material can be used and what can be included in it in their OCWs. And speaking particularly for MIT, our plan is to zero in on one or two courses in particular that are under development where we can employ this code on a very select basis. So that will probably take place, I would say, towards the end of 2009 and early 2010 is when we're going to make those choices. The staff needs to be trained on this code and get a little Fair Use 101, because we all have our areas of expertise at our organizations, but not everyone is an IP expert, just like I couldn't code my way out of a room, you know. We also have to figure out, this is going to probably take a long time, how to mark and tag the items that we are keeping, designating them as these are being kept in under a fair use claim as separate from material that's being licensed to the user under our Master Creative Commons license. So that's the preview of the code, stay tuned and look for it coming in September. Thanks.
Thank you. We'll be holding questions till the end. We're going to have some time for questions and discussion with both speakers. I'd like now to introduce Lila Bailey. And Lila is a counselor for ccLearn, which is part of the Creative Commons initiative, and she is a Silicon Valley lawyer.
I was.
Was, sorry, excuse me. Thought you said one Silicon
I still
Valley
technically
lawyer always a...
Yeah.
Worked for the man, now works for the people.
How do I do this? All right, I'm a Mac user.
Mac versus PC wars.
Okay.
So here.
Awesome. Okay. So I'm going to just take a quick show of hands. How many people here are not from the United States? Okay. And how many people here are not lawyers? All right, that's what I thought. Okay. Fantastic. So as Lindsey mentioned, my project has sort of arisen out of the fair use project that came up with the OpenCourseWare Consortium. ccLearn consulted on the development of the Code of Best Practices. And at the same time, throughout the process of working on the code, we also wanted to be thinking about this from a global perspective, which is kind of what CC does. So go ahead. So just to sort of telescope out a bit, our goal in general as an OER community is to have OER that works for everybody everywhere. And so in order to do this, we're trying to build a global learning commons. And we at ccLearn feel that there are certain inherent attributes that are required for the components of a global learning commons so that everything is both open. You can go forward. So open, and here by open, we really are talking about the license status, a license that allows the free sharing and adaptation and translation of works at a minimum. And also interoperability. It's really important that not only that they're licensed to be used in these ways, but also that the resources can then be recombined and put back into the global learning commons. So these are sort of the foundational principles that we work from. But of course, there are roadblocks. And there are lots of roadblocks here to building the global learning commons. The one I'm going to focus on is copyright law. To be clear, though, of course, Creative Commons is not anti-copyright. We rely on copyright to build our clear licenses that are able to tell everybody exactly what permissions are allowed with any given piece of content. However, despite our best efforts, the world is probably never going to come around to every single object in the world being CC licensed. So many of the resources, and this is the exact problem that Lindsey framed in the last presentation, many resources are simply only available under all rights reserved copyright. And because all rights reserved copyright basically says you can't do anything with this material unless you ask permission of the author, we consider that to be not open. And beyond that, copyright law is not standard throughout the world. So US copyright law is different from copyright law in South Africa, in the UK, in Nigeria, Uganda, all these places where we have partners and we all want to be working together. Unfortunately, the default rules of copyright are not standard throughout the world. And so this is really the problem that Lindsey framed, is when teachers are coming together to build open educational resources and combining all rights reserved or really any incompatibly licensed stuff. So I may say all rights reserved, but really the problems here come up when we're talking about even CC licensed works that have a no derivatives term on them. We at ccLearn don't really consider that to be open in the sense of the global learning commons and in the sense of OER, because translation and adaptation are so crucial to what open educational resources are. So, you know, you can go ahead. So the problem really is that most teachers and educators are used to their own classroom format. They're used to thinking about what they can do on the ground in their own country in privacy, where no copyright owners are there looking over their shoulders and seeing what's going on. But when they want to start engaging in OER, well, they're now suddenly exposed to the whole world and the whole world watching them. And the question really then is, if you're combining all rights reserved or third-party content that you don't own, that's licensed under anything other than the license you want to release your stuff under, which we would hope would be CC BY, but so then the question is, what happens downstream? Can downstream users in other countries actually take those materials and adapt them, translate them, and then reshare them back into the global learning commons? This is really what we're trying to foster. But when we're sort of pulling all of this incompatible content into a single OER, there's just a question about what happens. And so many different OER creators have sort of developed techniques for managing this incompatible content. There are certain rules of thumb, like, oh, we only take a little bit. What's a little bit? It's unclear. Or simply taking the stuff out and linking to a website that hosts the content, things like that. The technique that I'm going to focus on, because it's the sort of big morass right now, is when we decide to rely on what I'll refer to as copyright exceptions and limitations. You may or may not have heard that term before. I had not heard that term before as a US copyright lawyer, because I was only thinking about things like fair use in my previous practice. But internationally, every copyright law has some constraints on the exclusive rights that are granted to owners. And copyright exceptions and limitations provide sort of legal ways for people to use copyrighted material without permission. In some countries, this is done through compulsory statutory licensing, so you can do what you want, but you have to pay. In the United States, you just rely on fair use and you don't have to pay. So I'm going to just go through a couple of different kinds of copyright exceptions and limitations so you get a sense of the spectrum. I am not actually an expert in every country's laws. I've pretty much mostly studied US law and recently have learned a lot about fair dealing in a variety of Commonwealth nations. But I also know that there's, like, on the continent of Europe, for example, they have totally different, world where moral rights really play a huge role. And so a lot of this stuff is really just from a US and Commonwealth perspective, because that's what I know about right now. I'm hoping to learn more. So a couple of different categories of copyright exceptions and limitations. So the first in US copyright law, and this exists in a lot of other places as well, is that the material that you create has to be original. You can't copyright simply the phone book. That's like the classic. It's even if it took you a long time and a lot of money and a huge amount of investment of time and resources into building the phone book, you can't copyright it because it's not actually original. There's a de minimis, which means you just only took a little bit. This sometimes gets a little bit confused with the part of the fair use test that is the amount that's taken. De minimis really means like a tiny, tiny, tiny little bit, and almost never wins in court. The idea expression dichotomy, what this refers to is that you can't copyright facts in the world. You can't copyright information. You can only copyright the expression of ideas. Now, in some countries, this doesn't work. It doesn't work quite this way. For example, in the European Union, there's something called the Database Directive, which basically gives copyright-like protection to databases. And so basically they're locking down under copyright-like protections data, which makes a lot of problems for our friends at Science Commons. Then there's something called the first sale doctrine, or exhaustion, which is once you as the copyright holder have sold or otherwise gotten rid of, given it away, a copy of your work, you no longer control that particular physical copy. This is what allows us to have lending libraries and used books. So it's actually a pretty important part of our law and our public education system. Unfortunately, as we're moving more to digital, there is no physical copy to be getting rid of. So this exception is becoming sort of more and more and more constrained. In the United States, all government works are automatically in the public domain. This is not true also in many places. Canada has crown copyright, which means the government actually has copyright that they can sell and exploit however they want. But in the US, public works are in the public domain. There is fair use, which Lindsey told you a bit about. And then there are also a number of specific carve-outs for educational use or private study exceptions that come up. We have the Teach Act here in the US, but there are others as well throughout the world. So even though there's things like the Berne Convention and the TRIPS Agreement, which are international treaties that try to align certain minimum copyright standards, copyright exceptions and limitations are really, really different throughout the world. Fair use is almost unique in the world. There is fair use in Israel and I believe also the Philippines, but that's it. So that's sort of, when we're thinking about this code of best practices and fair use, we need to think about sort of what that means for people that don't have fair use. Because it's just not compatible, almost like 9 times out of 10, a fair use analysis and a fair dealing analysis are just not going to line up. And I also want to be really clear that this isn't about trying to export fair use into other countries. There are many instances in which the laws of other countries allow things that fair use would not. For example, I'm just going to take this little case study hypo of a teacher who decides to make copies of 3 newspaper articles from different perspectives in order to teach a class about media bias. Now, in the privacy of your own classroom, probably, I mean, at least in the United States, this is not going to get you in trouble. I don't know that it will get you in trouble really anywhere as long as you're physically in the classroom. But once you sort of decide that you're going to put that on your blog and make it available to everybody under an open license, well, that could really substantially change the legal analysis. So in India, this would be allowed as long as it could be considered in the course of instruction. Any teacher and any student has the right under Indian law to make any number of copies that they want in the course of instruction. So as long as you could broadly say this is in the course of instruction, Indian law allows it. In the US, you have to go through this balancing test. You're like, well, did I take too much? Did I transform it enough? Did I harm the market of the copyright owners? All of those questions. And, different people will come out with different answers on that, even absolutely professional lawyers who know all of the case law. I had a big debate with Mike Carroll on this point, actually, under US law. So reasonable minds can differ as to how this is going to come out. I suspect he's probably right. Anyway, in the UK, this isn't allowed at all because the UK has very narrow categories of categories of uses that are considered to be freely usable, and it doesn't fall into any of them. They only have research and private study, which, oh, sorry, okay, go. So anyway, I'll tell you more about these specific exceptions if you're interested. I also have a working paper that I'll tell you about. More of that's in the paper. But the problem is, once you start spreading this stuff around, the flow of OER really stops at any given national border. It just becomes totally unclear to people outside the country what they're allowed to do with those materials. Which hurts the global learning commons. Sad. Moving on. So then, our big question that came up really at this meeting when we all got together at Michigan was, well, what can we do about this? It's really complicated and really confusing, and we just think we need a lot more information. So we had a very small meeting after the fair use meeting to sort of think about what strategies we can implement for just basically finding out more about how all of this is going to work. It's just a little cheesy, but we really want the whole community to come together to find a global solution. We're nervous about jurisdictions coming up with their own sort of separate projects, which is not to say that people shouldn't be leveraging the value of the laws of their own countries, but I think need to really come together to find out more about what the downstream impacts are going to be. Some things to think about in the meantime is really talking to educators and people who are creating OER from the outset to educate them about using as much open content as possible beforehand, and kind of getting the open spirit in there so that people like poor Lindsey and Garen don't have to spend all of their time cleaning up the materials after the fact. So that's one thing we can sort of do initially. But the next steps, and you can go ahead, is ccLearn has been collaborating with the folks at Michigan on building a copyright survey. We took a very similar approach to the approach that we took on the fair use study, which is not to study it from what does the law say, let's just sort of gather all the different laws and then find the lowest common denominator. That's really not what we're interested in. We were wanting to take the perspective of, well, what are people's practices? What are people doing? And what do they need to be able to do? And then let's think of what the solutions are around the law. It could be something like, we need a huge, major, global, international law reform, or there could be some practices that we could all engage in together that doesn't require sort of systemic change. It may require systemic change. But anyway, so this is our survey. We're actually holding an unconference tomorrow at 1:30 to sort of delve into this a little bit more deeply. But I would love it if everybody in this room would take a look at the survey, take the survey, give us your feedback. That would be fantastic. You can get to it from the OpenEd website. I have a few flyers. We just launched this actually in the previous session, or it's been launched, but this is sort of more it's coming out party. So this is available on our, it's through SurveyMonkey and also through our OpenEd website. And we're just wanting to encourage everybody to get on there, take the survey, and then let us know that you want to help us. That's sort of the main thing. And that's it.
We'll open it for questions.
Yeah. Okay. Do we want to do like questions for Lindsey first and then questions for me, or just
Let's have a free for all.
free for all?
And do they need to talk into the mic? Question? Okay.
I'm curious, you said that OER stops at the national border. So if I create an OER object in the United States and I try to abide by United States law, but a teacher someplace else wants to use it, or a student of mine someplace else wants to use it, who's really violating the laws in the other place? Is it me? Is it the other teachers? Is it the student?
You want to take this?
Sure. So that's something that we need to look at a little bit more closely, actually. That's sort of a process question or procedural question about like whose laws apply under what circumstances. Generally speaking, and this is very broad and kind of based on U.S. court interpretation, so caveat. But generally speaking, an infringement occurs in the location, well, so the law applies where the infringement occurs. So if you have a student in Ghana, and they download something and use it improperly under Ghanaian law in Ghana, that's the law that applies. So, and if you don't know, I think it's going to the feed. Anybody else?
I have two questions that I think relate to both, although I came to your session late, so I may be on the wrong page with it. Why doesn't MIT and similar like institutions use existing platforms to develop the things that you were describing, such as the Wikimedia Commons projects, where they have quite complex metadata projects, communities of practice already established, could certainly benefit from further participation? That's the first question. But on the same vein, why doesn't so-called global initiatives, which is a concerning word to me, identify more progressive legislation in other countries and build from there? So, for example, why isn't ccLearn on the basis of Indian law? Why are we on the basis of US law and then adjusting it to that? So why aren't we taking it from a so-called global perspective from the very go? Why are we using US as a basis to begin from?
The answer to your question about MIT OpenCourseWare's platform has to do with the timing of its birth. When the MIT OCW site was something we built as we used it, we were putting the planks down as we were crossing the bridge. And nothing existed at the time in 2001 that enabled us to do what we needed to do then. That's why, for example, our content management system is a Microsoft tool. I know. And why it's not built on Educommons or, open platforms and things like that. It really has to do with where it came into being in history. We are investigating ways to move in, to get away from these closed tools that make it hard to replicate. It's an ongoing process, and it's something that we're looking into because we know how valuable it would be to go in that direction.
So there is no reason not to do it. So that's
right, but I'm going to actually... Kate James is my colleague at MIT OpenCourseWare, and she's our production manager who knows a little bit more of the technical aspects of this.
Well, she may have oversold me, but I just wanted to, in answer that, bring up something that Arash brought up in the last one, is that I'm not sure that there can become a central place that's going to have, that's going to do and be everything, that it's going to work for every needs. When we're publishing at the rate of 100, 120 courses a year, and other schools are publishing at the rate of 10 a year, it may not be reasonable for us to all have the same systems. That said, we are trying really hard to work with ccLearn to come up with some standards to do things in the right way, so that at least at some level there will be some commonalities to enable search, to enable aggregation, etc. So,
thanks, Kate.
And to answer your second question, so Creative Commons licenses are not based only on US law. The unported version is actually based on international treaty law, and we've got over 50 different licenses that have been ported to all around the world. There is a US version, but there's an Australian version, and there's lots of versions. So the original version, when it was born in 2002, was based on US law. We're now at version 3.0. The generic version is actually based on international treaty law. It's not based on US law. And the porting process is one that not only involves linguistic translation, but legal adaptation. So it's actually not the case that it's a mere translation from English and US law at all. We have local experts, local copyright law experts in every jurisdiction that go through and say, well, this doesn't work under our law, and this is how it works here, and so they adapt it for the local use. And so because we learned the lesson that starting from US law upsets people and doesn't actually really work. That's why actually right now we are really focused on coming up with a globally minded solution first. And that doesn't mean to say that like this is going to be a US slapped onto everybody else version, or I mean the point is to have enough variety of opinions and jurisdictions represented in the process that it isn't just kind of like, well, it's us in the US talking to the folks in the UK and we're just going to do it our way. The whole idea of getting the entire movement involved from the ground up is so that doesn't happen. It doesn't have to be this translation process. That said, there may not be a harmonization possible. And so jurisdiction-specific solutions may be the only way to go. Like, that may be what we find from this survey. We don't know the answer to that yet. What's your question?
What's the problem putting just supporting the public domain?
What's the problem with just supporting the public domain? We would love it if you would just put your stuff in the public domain. That would be fantastic. That would be great. One thing to note is that the public domain does not exist everywhere in the world. There are countries that don't have an equivalent to that. And in addition, so in the US, we're used to thinking of like, oh, well, I can alienate all of my copyrights. Well, in other countries, there's something called moral rights, which is something that stays with the author no matter what you do with the economic rights. So for example, I think it's Japan and France. There are several countries where like, there's just no way to get rid of moral rights. Like you just can't do it. So the public domain as we think of it in the United States, it isn't an international concept. That also being said, we've developed a license called CC0, which has done, I think, probably the closest thing there is to putting your stuff in a global public domain. So we absolutely support the public domain. We've been working on that. We've got tools in the pipeline. And we would love it if everybody would just dump their stuff into the public domain, but we are realistic in thinking that, like, you know what, not every content producer is going to want to do that.
It's said in the law that it has to be an original work, and I very rarely come across anything I read that's original.
It's a low standard. It's a very low standard.
I want to also comment about the public domain question. If we relied on that at MIT, we'd have no OCW, because our faculty would not agree to release their teaching materials into the public domain.
And what's their argument? Why do they?
Because they feel very protective and proprietary over their teaching materials. I think you'll find that at many, 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 many educational institutions. It's their work, it's their life work. They put all their professional careers into developing it. It was hard enough to get the early adopters to consent to a Creative Commons license. All of the questions that some folks may have heard in the previous one that Arash and your colleague, whose name I can't remember, Derek, the responses that faculty give to the idea of going to an open OER environment. Why would I do this? What happens? I lose control. What if someone takes it and doesn't credit me? That's what prevents migration into the public domain, fear.
Is that the same reason MIT applied non-commercial? I imagine it.
Yes, it is, because the faculty did not want anyone to have the opportunity to monetize their content in any way.
And there was a debate about the judgment on that? Sorry. I've looked for it, but doesn't appear to be any documentation of a debate about the application of non-commercial in MIT's context, whether or not that was a wise decision to make, how it would look to MIT in the mid to long term, and things like that.
Yeah.
I think you're right, there is no documentation around that debate, and because it was so new when we started, we would agree to just about anything to get the faculty to agree to participate. So. Was it a question in the
It's more of a comment, really. I'm Martha Rands. I'm a copyright lawyer in Vancouver, and I'm new to open education, but I'm very aware of Creative Commons and work a lot with artists. That's actually most of what I do. And I think the question about the public domain and the point about fear is really germane. We don't understand it. We don't understand what copyright is. I think most people in this room don't understand what an artist actually does in the sense of creativity, with all the greatest respect to all the artists in the room. It's a really nebulous question. We have a national copyright consultation going on right now in Canada. Most people don't even know what's going on. There's very few, if any, participation from people who actually consider themselves creators, as opposed to content producers, content industry, content distribution networks. Open Video Alliance was full of people who are all about content, but not necessarily creating artistic, original work. And being the product of an academic father, I totally get nothing's original. At the same time, for many of the people that I work with, it is their life's work. And they are very afraid of letting it go. We are evolving, I think, a process. It started, I think, in some ways for us in 2002 with a licensing scheme that would enable us to recognize that need and move us forward. I look forward to best practices that are locally driven, discipline specific, that start to proliferate and that are funded so that we can do the necessary education around this stuff. Because every faculty member, you could, multiply that by 10,000 for all the students in that room who are interacting with that faculty, who themselves have aspirations to create, to produce, to make. And that's where I think we sort of really get into this. I'm excited by what you're doing and look forward to a discussion tomorrow at the VAG where we can talk a little bit about fair dealing and how this works for artists and really breaks down.
Great. There was a question over here. Yeah, how much time do we have?
Time's about up now.
Okay, so we'll do, this will be our last question. Yeah.
Okay.
There's going to be more time to talk about the OER survey, specifically tomorrow at the Unconference at 1:30.
Okay, I'll make this really quick. In a distance education environment, it's almost impossible to for your student population that could be all over the world to try and meet all these copyright laws, etc. Is it possible to use something like a proxy where you can push the responsibility back to the far end, to the student that accesses the material through a proxy into your distance education program? Or is that just sort of bypassing the copyright law?
Yeah, we can do a big OER pirate day. So it's a good question. I actually don't know the answer to that, honestly. I mean, there are places where copyright still kind of doesn't quite exist yet, and that's sort of where all the Napsters have put their servers and things like that. I don't know that that's a viable solution going forward because honestly, as the world comes closer together and we all get more and more global, those places aren't going to exist for very long, I promise you. So, I mean, it could be sort of like a wishful harbor for a couple of years, but I mean, even the Pirate Bay folks are in trouble now. They're all kind of in jail, so I don't think we want to go that route. Yeah.
And I can say at MIT, the higher administration would never consent to that activity. It's a non-starter at an institutional level.
I mean, that's absolutely right, and that's exactly the problem that we're trying to discover more information about and get a lot of voices and minds into thinking about what the solutions are, because I just don't think people have thought about this very hard, actually, at least not for our, so take the survey, come to the Young Conference, help us start thinking about, I mean, right now it's only in English, because that's what I know, but it would be awesome if we could translate it into more languages and get the study formally funded and build it out. So that is the goal, is to really address that concern. So,
Thank you very much.
great.